announcements before we get started with our guest speaker. And I guess when we do, y'all might want to move. I'll shift down to this side because I think the camera can't see on that side of the room. But so just to kind of recap, at last month's meeting, we elected all the officers except president. We got very low turnout or response from anybody who wanted to volunteer to be president. I gave it some more time until this meeting. And so if anybody else, wants to volunteer to be president, feel free to speak up now at all. I'll give us a few seconds to give somebody an opportunity. Well, I guess if no one else is volunteering, I will fill the position for a second term as president. Had some concern about this being legit with our bylaws, but after checking that yesterday, it does state that a president can serve 2 successive terms, but not a third term. So unless anybody has any objection to that, I will fill the role for another year. And we'll move on to the new business. Next month's meeting is going to be our usual ethics PDH opportunity with Steve Tweet is going to be giving us that presentation. That's going to be on November 18th. It will also be a virtual meeting. And today's meeting, we've got Ricky Eiland from Hemp Hill Construction. We're gonna talk about a contractor's perspective on plans and specifications and just kind of the construction process altogether. It's gonna just be more of a discussion. We wanted to have, similar to the meeting we had last month with Charles Busby, where we just had a few of us in a room together having an open discussion. So feel free to unmute yourself and jump in at any time and, give an opinion or ask a question. I'm going to try to open up the chat thing too. Thank you, Jennifer. Jennifer's going to try to help us keep track of the chat box too, in case you want to just type in your questions or comments there. And then at the end of the discussion, we'll give a poll question and you can email your answer back to me, and we will send out the PDH certificates that way, like we've been doing in the past couple meetings. So we'll get Ricky to help us think of what that question might be once we get towards the end of the meeting. So let's shift down a little bit. Ricky, Walt, sorry to make y'all move, but I know the camera's not picking y'all up over there. And I just want to make sure we give our audience a good show of who they're talking to. So with that, I'll turn it over to you, Ricky. Give an introduction or whatever you want to do to get started, and then we'll get into the questions.
First of all, this is a little awkward, talking to a touch screen. Fortunately, I do know some names up here, and makes me feel a little more comfortable. But as he mentioned, my name's Ricky Eiland. I work for Hemp Hill Construction. Been doing this for about 43 years. I estimate, order materials, bid jobs out from start to finish. And typically, you don't see that much anymore. We now, the younger generation, you have estimators, you have project managers, and a lot of support. But the older school still can do most everything. We do need help with the computers, and That's our weakness.
Hey,
Now-
Dad.
Isabel, get off there. Excuse me, that was my daughter. She's supposed to be in school today. But what I'd like to go over a few things. I made some notes to try to keep it organized as I can. And if you have a question during the middle of this, I would appreciate that you ask it. You don't have to wait to the end. And if I hit a topic that strikes a nerve with you or you'd like to hear about at that point in time, let's do it while it's fresh. First of all, I'm going to give you an idea of how a contractor does pre-bid steps, which involves everything that y'all do from an engineering standpoint. And the first heading would be the advertisement instruction to bidders. First thing we do when we get a set of specs is we review the bid time and your date, the contract time, liquidated damages, retainage percentage, and the warranty period. Next thing we go to is to determine if you have any DBE goals and if there's a wage determination and AIS requirements. And once we do that, we start passing things along and putting ads out or doing whatever we have to do to make these things work. Then we go to the general conditions. And one of the things we discuss is insurance requirements, builder's risk, owner's protective, railroad, etc. And I'm going to put a high point on the builder's risk, and I'm going to come back to that in a little bit and give you a take on our side of that. And we'll check on the additional bond requirements. MDOT now is requiring additional bonding for anything we do on the state highway, which is an additional cost that we have to include in our regular bonding. We go through the differing site condition clause to see if there is a clause. If there is not a clause, typically, I don't say we won't bid it, but we typically frown on it just to the fact that if there's nothing that can change conditions or help you, then we're not going to take the liability. But most of the time, there is a different site condition clause in most all contracts and specs. Another important aspect is the payment terms. Is it net 30, 45, or 60? And stored material. Stored material is a huge issue with us when we're on a large job, such as the one we just did in Biloxi, was 2.5 years. In order to maintain the pricing from the vendors and keep everything, we have to be able to bring material in. If we can't store that material and get paid for it, then we're ultimately financing the job. We try to examine, and I'm also going to bring this back up in a little bit, is substantial completion. Substantial completion is a huge issue contractually, and a lot of times is not clear and specific. It's very important when substantial completion is to be set aside and used, and what the warranty period, when it starts and the length of time, but when does the substantial completion and the warranty period and the final payment all tie in? And there are so many specs out there that are really vague that do not define those issues. It may say substantial completion is given upon final inspection. Well, then it leaves a gap of when the warranty takes over. So those are issues that y'all could clean up and help not only us, but yourself. One thing we find out is gray areas are the worst thing that we can have. We would rather a set of specs and plans be a Bible. If we know what you want, we can provide it. And what the gray area does is allow attorneys to keep jobs. If you got an opinion and I've got an opinion and it's not definite in those specs, then someone can take that and argue it and right, wrong, or indifferent. So the gray areas need to be as specific as they possibly can. And then we'll go to the technical specs. We look for the measurement and payment. Measurement and payment is a very important item, and it needs to be defined. And I don't know that all of you are dealing utilities or so forth, but that's what we typically do. But one of the big issues, is just an example, is say ductile line fittings. When you say you pay for the pound, what are you paying for the weight of? Are you paying the weight of mega lugs? Are you paying for accessories? What's included, what's excluded. But the more specific you can be, the less change orders you're going to have throughout the job. It's just real important that you define what you want. You're not being blunt or out of the way to say in the specs what you want. It's more benefit to everybody. So the more specific you can be, the better you are. Is bedding required? You see a lot of times a very vague bedding spec. You'll show a detail in the back of bedding, and then you'll refer back to the specs on what that bedding needs to be, but they don't always define the type of bedding. Do you want stone bedding? Do you want stone and sand? Do you want sand? There's a lot of things that change between the spec and the plans that would help if it was just more defined. Compaction test, who's responsible for the testing? Is the contractor responsible? And if he is, what are the requirements? Where do you want it? How often? And even if the owner is furnishing it, what are the requirements that the contractor needs to do to provide these compaction tests for you? Another issue we have is clearing and grubbing. When there's a clearing and grubbing item, it's kind of generic. It just says clear and grub. Does the clearing and grubbing require a full limit of an easement? Is it a 50-foot easement, or are you only requiring clearing for the pipeline? Do stumps removed? Can it be burned? All of those things, again, if are defined in your specs, is less room for error and less room for a change order at the end. This is a big item. This is my last one and on this subject, but mobilization. Mobilization is set up, excuse me, in most jobs, and most of them are defined by a percentage of the contract that you're allowed to use. What a lot of people don't understand is that mobilization to a contractor is not strictly mobilization. There are things that go in to mobilization that we dump, I say, as indirect cost. For an example, if I'm laying pipe, all I'm doing is I'm bidding the pipe item for a pipe cost. I have items such as insurance, I have mobilization, I have per diem, I have railroad insurance, I have extra boxes that are bought. There are things that you don't put into that item or put in that specific item, so you dump it in mobilization. And at the end of bidding these projects, if that item of mobilization is, say, 6% of your bid, and you actually have 10% of absorbed items, 4% of them items have to go into other items, which makes your bid possibly look a little distorted. You put it in pipe or other items of work that's really not just contributed to that line of work. So that's something we have to explain a lot on. So you can't just limit your amount of mobilization and expect the contractor to say, okay, I'm only going to give you the cost of 6%. Whatever that remaining cost is has to be dispersed through other areas. And I know a lot of people don't like the word mobilization, don't like to pay up front. And there's other ways of doing it. You can spread it out throughout the job. Now, we don't like it to be 50% at the beginning and 50% at the end, for sure, because we're spending all of those items throughout the job, not necessarily at the end.
That 6% example you're using right there, is that like on some specs it's it's specified that your mobilization costs can only be 6% of your total
That's,
other?
that's correct.
Okay.
The city
I
of
haven't
Biloxi,
seen it
for
like
an
that
example,
before.
all of these projects that's being done for the city of Biloxi
Yeah.
limit you to 6%.
I
Now,
got
they're
you.
not the only one. Most all the jobs we do have a 5%, 6%, 10% item
Right.
that you're allowed to put in there. If
Right.
not, a lot of the contractors will stick 90% of the whole job in that mobilization and front their money up front.
Yeah.
But we have no problem with a limit of whatever you want,
Yeah.
6%, 10%, long as we know what it is and if it's
Yeah.
spelled out. But just because you say that that's 6%, you got to understand that the cost has to be distributed through other items. And if you have a water line that's worth $10 a foot, that water line item may suddenly now go to $30 a foot. And people think, well, you got a high price, you got an unbalanced bid. Well, you have to put your money somewhere.
Right.
For an example, a bond on a $20 million job is $200,000.
Right.
You'll eat up your mobilization percentage real quick by paying your bonds, which have to be paid at the very first of the job. So there's a lot of things like that that y'all need to know that what we do whenever we max amount of a mob, it isn't trying to get money up front, it's trying to get covered for front end costs.
For distributing it, I've seen it where and to me, this is the most fair way to do it, where you get maybe half of it on the first pay app, and then, the rest of it gets paid over the next couple pay apps based on a percentage, and it doesn't hold it all the way to the end.
And that's the way Biloxi does, or did. I'm doing a project in Mobile now for malls, and they are allowing you 10% mobilization, but they're only paying you 50% on the first estimate and 50% on the last estimate. You're not doing very well to put all your money in mob. If you're going to be a year and a half getting money, you're still going to have to distribute it somewhere. So by limiting it doesn't change the owner's cost. It just changes where that money's being distributed throughout the course of the job. Next thing we'd look at would be the plans. And I don't know how good you're going to see this, and I hope nobody's up here that this would apply to. But plans to us, I don't say they're gone down over the years, but the quality of what you're seeing on a piece of paper is really not what you saw 30 years. And I think a lot of that's to do with the computers.
Yeah.
And I went to a school for our continuing education license, and it was given by an engineer. And he said that the downfall in the construction industry isn't as much as the contractors or other things, but it's the engineers. And he didn't mean that in a bad sort of way. What he meant is we're only as good as the plans and specs that are given. And if your foundation is good, that job's going to be good. And the better your plans and the better your specs, the less litigation you run into, the less problems that a contractor has a question in that gray area again. But to give you a quick example, I don't know how good you can see it, but I bid a job last week. And this was my cover sheet to tell me how to get to the job.
Oh, wow.
This is a site plan. I don't know if you can see it or not, but I got an interstate and a highway, and then there's a star drawn somewhere in between it. And it's like 50-mile scale. So that's actual something that we did. So the quality of the plans and the specs really, depend on y'all helping us give you a better product.
Right.
Oh,
I can see that. I definitely have seen, and put together plans that you can be proud of just because they're easy to read, they're aesthetically pleasing, and to me that goes a long way too, because then versus something like this or something that's just got a bunch of text thrown on it and nothing's
there's too much copying and pasting these
Right.
days.
Oh, yeah.
We'll see a set of
Mhm.
plans that show a street and a right of way, and then there's a line drawn for a utility.
Right.
Well, where does it go? How close to the road? I
Right.
mean,
Yeah.
it's drawn through power poles and stuff, just
Yeah.
because that's where the
Yeah.
CADs took it. So,
Mhm. One thing I've also seen is that a lot of people don't put utilities on the plans, and I think that's a huge mistake.
and
Even
I'm
if-
gonna
even
cover
if
that
you don't
in
have-
something that you're
Oh, yeah.
100% right. Without the utilities
Yeah.
being shown, and how do you design something to
Mhm.
put somewhere when you don't know where
Mhm.
you want it put?
Mhm.
And
Yeah.
why is the contractor, and of course I'm being contractor biased, why is
Yeah.
the contractor responsible for interpreting or building something that you wasn't sure about in your
Yeah.
drawing, or you would have put it there?
Yeah.
So,
Yeah.
and we have great relationships with our engineers, so I don't want the engineers to think I'm beating them up. We got as many issues as engineers got, I promise you.
Ricky, how do you handle when the owner is even aware, like the plans have all the known utilities that are known, and all utilities may not be shown on plans because just no one knows, or municipalities have been built out over multiple decades.
Walt, that's a good question. I mean, you can't blame the owner for not knowing something and be given something, but that's where a change order will have to be inevitable. But people are so frowned on change orders. It's like, I'm not giving you a change order. Well, you didn't tell me they were here.
Yeah.
You didn't know. I didn't know either. So it's fair to everybody that a change order be issued. Had
Yeah.
you have known it, then that cost would have been in the bid to begin with.
Right.
If you had have showed me these utilities, this extra cost that's going to incur in the change order would have been part of your original bid. So,
Right.
that's a good question. I'm going to jump through some things, and I brought some stuff that I hope will help you and not bore you. And, if it does, then bear with me and I'll make this all short and sweet. I brought some literature that we use and that we have on file to help prepare for the bids and build them. But this is what I have here is a section out of a set of specs that is called a contract closeout. And this was taken out of a set of specs that in our mind was a good set of specs. It defined what you wanted and what was to be done.
Mhm.
And in it, I've highlighted it, substantial completion. When the contractor considers the work is substantially complete, he shall submit to the owner a written notice that the work or design portion thereof is substantially complete. A list of items to be completed or corrected. This is what's important. So within 5 days, after the receipt of notice, the owner shall make an inspection. So it is a defined time. It's not a matter I'm saying I'm substantially complete, and the owner says, well, we'll get to you in 6 months.
Mhm.
What is the time frame that goes on between these completions and the next step? When the owner finds that the work is substantially complete, he will prepare and deliver to the owner a tentative certificate of substantial completion with a tentative list of items to be completed or corrected before final payment is in accordance with the general and supplemental conditions. Final inspection. The owner will make an inspection to verify the status of completion within 5 working days after such receipt of such certificate.
Yeah.
Again, there is a step that goes on, and people are not wondering what the time frame is. It's like shop drawings. We turn in shop drawings and there's no definition of how long is it going to take to get my shop drawing. Well, I got them to you day one and you've had them for 40 days. And I can't argue that that's too long. You can argue it's not long enough because there's nothing definite in there.
Right.
Again, the gray areas and speculation is the highest cost of driving contracts up. When we have to speculate something, we're throwing in the kitchen sink.
Yeah.
But if we know what that cost is, we can
Right.
identify it.
Right.
Application for payment. Upon receipt of approval of the final change order, the contractor shall submit an application for payment in accordance with procedures and requirements stated in the general conditions. Upon receipt of the owner's acceptance of the work, the contractor shall submit an affidavit upon that the project is clear of all materials and labor liens. Upon receipt of the affidavit of clean liens, the contractor shall submit an application for payment to owner requesting the release of the project retainage with the certificate attached to the owner to pay retainage. The owner shall review the application for payment of the project retainage, and if in order shall submit an application for payment requesting the release of the project retainage with the attached certificate to the owner for retainage. So again, it's defined things that help us all
Right.
have a clear view of what you want, what you expect, and when to do it, and how long it's going to take to do it.
Yeah.
Ricky, that spec you were reading, substantial completion, did that contract define what very specifically substantial completion is? Sometimes that's you say it's substantially complete, and I may say, well, in my mind, it's not necessarily.
All right, well, let me tell you the definition of substantial completion. Well, glad you asked. Substantial completion is easy to define. It is the stage of completion where the project is fit for occupancy and for use of its intended purpose.
Yeah, that's what I've seen
So-
most often in specs for it.
When you've got the product that you've paid us to do, and now you're receiving revenue for that product, for water services, sewer services, or whatever, that's, to us, is substantially complete.
Right.
Now, that does not take away any of our responsibility or our obligation to finish completing the job, selling the job, cleaning it up, whatever. You're holding my retainage for that. Why would you want more? I mean,
Yeah.
so
I mean, on a water project, like you said, it's easy to know. I mean, it may be not got everybody hooked up yet, but they have the ability to hook up.
that's right.
If they want to. If you're building a road, you got all lanes open, no
That's right.
traffic, signalization to make people detour around something that's not finished.
Back to that note, substantial completion is one of the more significant milestones in a construction project, affecting the rights and responsibilities of both the owner and the contractor. The impact may include release of retained contract funds, responsibility for insurance, and commencement of statutory claim limitation periods. Substantial completion refers to the ability to use the work, building, or whatever goes along with it, for its intended purpose. At a bare minimum, this means at least obtaining certificate of occupancy from the building official,
Right.
or the use of water and sewer and so forth.
Right.
Other considerations for substantial completion include warranty start date, transfer of utility bills to the owner, punch list, and partial payment release of intent retention. We got a contract that says that substantial completion is the definition is very vague, and that final payment does not get made, or our warranty does not get started until we receive final payment. But it does not define when the final payment is going to be issued.
Mm,
You know anything about that, Walton?
Yes, sir, I do.
So, and from a contractor standpoint, that's something that's very important. You've held 5%, 10%, 2.5% of our money now for 3 years. And I'm not picking on Walt, but that is your overhead and profit. So you've been working and financing a job now for essentially 3 years that you've not had access to your money. And to hold it even longer, or to make your warranty period longer because you're waiting on money, to us is kind of it's an increased cost. So now instead of a 2-year warranty, you're getting 2.5 years.
Right. Yeah.
And those are things that we have to live with, and we understand them. But as they're defined, it just makes it easier to be defined and understand what somebody's wanting and not wanting. And he did a good job of defining it. I couldn't argue it, that's for sure.
So that's all kind of, I guess that was pre-bid and did kind of get into construction issues.
Yeah, I've
too.
moved right along.
Right,
We
yeah.
got bid a job and started it, now we completed it.
Yeah.
So, but in between, now I'm gonna throw some things that's kind of happened in between real quick and,
Okay.
and give you some ideas that, and if I start running too long, stop me, but I hope not. One of the very important things that y'all, from an engineering standpoint, need to make sure is that in every set of specifications, you have the golden rule. Golden rule is a law that's set by the state, cannot be altered except by the state. And that defines that if an out-of-town contractor comes in, he has to submit a letter that shows that his state indemnifies or does the same thing that our state does. And I'm gonna give you a perfect example, and I may step on a toe by doing this, but I've got a class or an action, a suit that involved, can I mention names?
It's
It's
if
public,
you feel comfortable
Yates
with
in the
it.
city of Waverly.
Okay.
Okay, in 2012, Yates bid a job in Waverly, and they were second, and they protested the job due to the fact that there was not a golden rule submitted by the out-of-town contractor. But the city of Waverly chose to go ahead and award the job anyway. After the job had been awarded and built, they were sued and they won lost profits from the job because they were not given the job.
Yeah.
The statute further provides that where a non-resident contractor fails to attach its state current law related to the state's treatment of non-resident contractors, such bids shall be rejected. And what we see a lot of times is these local municipalities and local towns want to alter some of the rules. You can't alter state and federal laws. And these are state and federal laws that are mandated and require attention. I mentioned a few minutes ago about builder's risk. From a contractor's standpoint, the biggest cost that an owner is paying, but we put the cost in these bids of whatever y'all require, is a builder's risk. I've been doing this for 43 years. Never claimed on builder's risk. Builder's risk should be the contractor's responsibility. If I got a load of pipe out there and it gets stolen, I'm not gonna claim it on builder's risk. I'm gonna claim it on my insurance to pay for it. But when y'all require builder's insurance or builder's risk insurance, y'all paying for it. And let me read you something real quick. Builder's risk insurance is a special type of property insurance which indemnifies against damage to buildings while they are under construction. The builder's risk is mainly for buildings.
Right.
The problem is builder's risk writers write the contract for the insurance policy for the amount of the whole contract, not for the building. You got a $5 million contract and you got a $20,000 building, you just bought an insurance policy for $5 million.
Right.
Builder's risk insurance is coverage that protects a person's or organization's insurable interest in materials, fixtures, and or equipment being used. However, it does not cover earthquake, flood, and hurricane damage, which is what on the coast y'all think you are getting insurance for, which it does not cover.
Yeah.
So if you was to pay for stored material and you lose all that, the owner still got the money. We got to replace it. It isn't the owner that's got to replace it.
Yeah.
Insurance costs generally run between 1% and 4% of the construction cost, depending upon the type of insurance purchased. For an example, a cost to the owner that typically don't apply, cost of builder's risk on a $20 million job could cost the owner anywhere from $200,000 to $800,000 that a contractor is putting in his bid that will never be used.
Yeah.
So in these size jobs down here, $20 million, you start running builder's risk in there. I mean, you're escalating the cost of these things. And those are items that stuck into your mold and scattered through other places that you won't get back because they're having to be absorbed.
So if fire, earthquake, flood, and all that isn't covered, what is covered by,
Our insurance, or do we have to do it? What is the owner having to,
well, no,
What-
I know you saying that like if materials get stolen, that
what if the
y'all's
building
insu-
burned down? My insurance takes care of it. As
Right,
long as it's still mine, my insurance takes care of it. If
Right.
anyone was to take out builder's risk, it would be us
right,
to insure our stuff until it turns over to y'all.
right,
We're ultimately responsible for anything that happens to it until you've taken ownership.
right.
So
That's the
why,
way I've seen it, is it requires the contractor to have that policy in place.
it requires a builder's risk policy to the owner.
Oh, okay,
So we're having to supply the owner with a builder's risk policy.
yeah,
When it
okay,
says builder's risk shall be obtained. So our insurance covers insurance and builder's risk. It covers all of these things. That's what the
Right.
insurance we have. But again, what does it matter if we have that insurance or not? City's indemnified. It's our responsibility. You hadn't bought it. You hadn't paid for it. Well, say you had paid for it. You still got 10% retainage on other items that will cover that cost until everything's handled and done.
Yeah.
To us, it's a wasted amount of money
Yeah.
that somebody's spending that they get nothing out of. And out of all these people on this screen, I would like to know, has anybody ever used builder's risk? I've
Yeah,
never used it,
I haven't seen it being used.
but we've put some cost in it, that in my opinion could be eliminated. Am I running too long?
No, we're good on time. We've got, another 50 minutes if you want
I don't want that much.
it.
Ricky, what was the builder's risk supposed to be covering then?
It covers theft, which is
Okay.
not y'all's problem. That's our problem.
So if we paid for, say, the cost of an.
Builder's risk covers perils such as fire, wind, theft, and vandalism. So if somebody come and stole my rack of pipe, my insurance that you paid for is gonna already cover it, but now I've got a builder's risk that I won't claim on builder's risk, I just claim it on my insurance.
If we paid, say, invoice costs for all your stored materials, say it was a substantial amount of, plastic pipe.
Okay.
That went up in flames, but we as an owner do not know if your company's insurance policy has lapsed or didn't meet that level of coverage. Is
What
that
does it
not-
matter? You don't have to pay for stored material again, I gotta replace it,
It always.
or I don't get paid for putting it in.
That's-
I'm in default of contract. If I got 500 feet of pipe out there that you paid for, and that pipe gets stolen or burned up or something, well, I either gotta go buy 500 feet, my insurance company's gotta pay me for it, or I gotta do something where I am in, default of contract, because I don't have 500 feet to complete my contract. You hold all the rules anyway.
Right,
Don't
but
even costing yourself anymore.
500 feet isn't much, but when we're dealing like, say, some of the large jobs, 20,000 feet, and you may not have the financial means. Like if your insurance lapses on your company, isn't that the purpose of the builder's risk?
That's why you got a bond. Okay, you're covered with a bond. And if you're concerned about people not having money or insurance, maybe you need to be doing more qualifying for people and not just allowing anybody
Yeah.
to bid the bigger projects. We're bidding jobs all over the southeast that we have to submit financial statements.
Yeah, I've seen that before too.
And
Yeah.
bank statements, and at least the owner knows he's getting somebody that if he goes defunct, what can happen? Because I'll be honest with you, it's gotten so crazy for people to be able to get a bond these days. I mean, 10 years ago, you could count on one hand, people could get a $1 million bond. It's outrageous. Somebody can get a $20 million bond. Now, how many people can do it? So the
Yeah.
bonding companies have relaxed on their requirements.
Yeah,
But your bond covers everything. You're 100%. The owner's never not 100% covered based on the bond. Another big issue we have, back when I came up and was young, everything was done on a handshake. You'd say, here it is, and we'd be done with it.
Mhm.
And it's been a hard transition for me. That's not the case anymore. Everything needs to be in writing, and no one needs to be insulted when they're asked to put it in writing or when they're asked to sign something. I have a little piece of paper that we use that I'd like to read for just a second, using an example. There was a job done and the prime contractor claimed that during construction, the engineering firm representative consented to the use of native soil for bedding rather than manufactured gravel and sand. Pipe ended up failing and they went into litigation and a lawsuit. And the city filed a motion for summary judgment arguing that the contractor failed to construct the pipeline in accordance with the plans and in particular that it neglected to abide by the aggregate bedding requirements. The trial court agreed and entered judgment for the city. The contractor appealed. And on the second appeal, when a contractor is bound to build according to plans and specifications prepared by the owner, the contractor will not be responsible for the consequences of defects in the plans and specifications. However, the contractor countered that its deviation from the bedding requirements was authorized by the city's engineer, and it pointed that out, although such authorization was verbal and otherwise undocumented. The court was convinced because the contract required all change directives to be in writing, and it contained a clause prohibiting the contractor from relying upon the engineer's site inspections or raising the engineer's observations as defense claims defective work. So they lost the case. It could have been the other way around. You know, the engineer directed you to do something. The importance of writing, and I tell my people every day, you can't get enough letters sitting down, and that's a shame. I mean, we spend half our time writing letters, but it will come back to haunt you at some point in time if everyone. The good old boy days is just over, where he says do this, do that. The attorneys have taken over the world.
Yeah. Yeah, I've seen, work change directives is not a full change order.
That's right.
But it at least acknowledges
what
there is a change that needs to be made, whether or not it amounts to a change order, but it at least puts it down in writing that something needs to be changed. And it's more like just documenting a field change.
Yeah.
The
word, I mean, in writing is so important these days and with the courts and so forth.
Yeah.
One thing that the engineers need to know is the importance of preparing the bid documents and the quantities as accurately as you can. And the reason that is so many times we find a set of plans and specs that are inaccurate as far as the quantities. Okay, the plans may show 500 feet for some reason, and the bid quantity is 100 feet. What a lot of times the engineer don't understand is that by state law, we cannot exceed and continue to do any work if your contract has expired. Contractually, as far as the amount of money. If we run out of money, we can't keep going by law unless you authorize a change order. And so many engineers will wait till the very last day, and we're still laying, and you got a half a mile left to go, and it's visible. We're not to the finish line. Well, your quantity's overrun. You had them set up. They were, we didn't get here by change order. We got here by doing the quantity that you had on the plan, but for some reason or another, it wasn't the right quantity. But if we get to the contract amount, we have to, by law, shut the job down until there's authorization to add money to that contract.
Okay.
Just like if you brought somebody to your house and he said, I'm going to fix your roof for $100, and he gets out there and he sends you a bill for $500 and y'all sign the contract for $100, you're only liable for $100.
Yeah.
We have a lot, and people think, well, you want the change order. I'm not wanting the change order. I'm wanting to extend the contract amount to the quantities that you had set up in the bid, but someone had neglected to fill the quantities out correctly.
I see a lot of times we rely on summary change orders to do that.
Well, that's
And-
fine and dandy, but you're
Yeah.
normally under the contract when you do that, but you can't,
Yeah,
you do a summary change order at the very end.
right,
After the contract has been established, and your summary items will become what your contract is, but it won't be higher than what the contract,
Right.
it will always be lower.
right,
Because if it's done by law and correctly, that contractor can't bill you for $150 if his contract's for $100.
Yeah.
It's
Yeah.
not. You don't have to pay me if I did the work. If I do the work for more than what my contract is
Right.
signed for, by law, you don't have to pay me.
right.
So we will
Yeah.
shut the job down, and we try to let people know, this is happening.
Oh,
You're
yeah.
getting close. You're signing an estimate every month. You
Yeah.
know what we got going. Let's get something in order here.
Yeah,
Hey, Ricky,
Hey, Jack.
question here. If there's an item that you're unsure of the quantity, is going to be, say ductile iron fittings, where you might, estimate 1,000, but you're not sure if that's going to go way over or way under. Would you suggest prior to bid increasing your quantity, or just putting a contingency item, as an overall, I guess, item in the contract? That way your contract doesn't run over and you're not scrambling for change orders.
I think you need to put it in ahead of time. I think that, and we do this a lot, is try to bring it to the attention of the engineer that, hey, your quantities don't look correct. A lot of times they don't want to change them. Well, this is what we come up with. And we're trying to give you notice ahead of time, instead of 1,000 pounds, it's going to be 5,000 pounds of fittings. So you're going to overrun this quantity. We find so many times that the plans show something and the quantities don't match the plans.
Mhm.
So
For
in that
whatever
scenario,
Huh?
Ricky, that you and Jack are speaking about, say, the planned quantity as laid out by the engineer on the bid proposal is 1,000 pounds. But by looking at the plans that in fact it's going to be 5,000. How would you bid that?
I would
Unit
take
price.
advantage of it. I mean, I'm giving you a fair answer. Again, if everybody's in it for themselves,
Right,
but I'm not doing nothing wrong or illegal, especially if I bring it to your attention and say, hey, do something. So, yeah, I would bid that quantity high, knowing that I'm going to overrun that quantity.
yeah,
And that's maybe an area that I stick some of that absorbed money that I talked about that I'm having to
right,
throw throughout the bid. So, you need to try to know your quantities.
yeah. What Jack brought up a good point that I think is a good idea, especially on building projects, is a contingency allowance where you have a small amount of money set up for minor changes that come up along the way.
I don't know if any of these engineers here work for MAWS, but MAWS, which is Mobile Air, Water, and Sewer, several years ago, and I was raised in Mobile and worked there for forever, but they got MAWS will not approve a change order. It's not going to happen. The engineer probably won't ever do another job for MAWS. They won't do a change order. So every job that they do, typically every item is got a 10% contingency built into that item. And then they give a contingency item for $500,000 or whatever the size job is, just so if things happen, they got the money in the contract. So you never have to go back and say, my contract's already completed, I need a change order. You got money in it. From a contractor standpoint, we don't like that. Because when you're increasing, now I like the contingency items to put stuff in, but whenever you start giving a contingency for every single item, say for 10%, I've incorporated money into an item that's 10% greater than what I'm going to get the value out of. So if I divide $100 into 110, and I'm only going to get 100, I'm getting less money out of my. I can't distribute my cost evenly. But the contingency item is a very good item. And there are ways that to do it. We just got through with two big jobs over in Shreveport on. They have a consent decree. And they did the same thing. They put $1 million worth of contingency items because they didn't know what they were going to run into. And every time you run into something, they had it defined in the spec that would be paid for as time and material. And they used the green/blue book rates for that area. And everything was defined, and they would know what to do, and they would pay you and subtract that from that item. And we never run over the contracts. You had money there to handle those kind of things. I'm getting real close to finishing. Prompt Payment Act is an important act that we look at. And municipalities, and Walt helped us on knowing some of this years ago, but there is a Prompt Payment Act that applies. Progress payments from the public entity to the prime contractor are governed by the terms of the contract. However, progress payments must be made within 45 days in order to avoid interest penalties. This is a state law. When it's time for final payment, the public entity must release the funds within 45 days of one of the following events. 1, substantial completion of the project. 2, beneficial use or occupation by the entity. Or 3, certification of completion by the architect, engineer, or the contracting authority, whichever occurs first. Once the prime contractor receives any type of payment, they must pay their subcontractors and suppliers within 15 days. Penalties for late payments on public projects. Late or otherwise wrongfully withheld payments will be subject to interest penalties, the rate of which will vary depending on who is receiving payment. Late payments to prime contractors will accrue interest at 1% per month, starting on the 31st day after payment was set within the contract. Regarding payments to subcontractors, late payments will be penalized at 0.5% interest, but cannot exceed 15% of the outstanding balance. So it's important that the engineers get the estimates from the contractor in a timely manner, get them to the owner, and instead of holding them for a lengthy time, and then the owner has a duty to pay within a certain amount of time.
Right. Yeah, I know me personally, I take that role very seriously because I know,
when you're dealing with our money,
exactly, it's holding up an entire company's, paycheck, and y'all have employees that y'all are paying from that too. So yeah, I always, make a special effort to get things reviewed and approved for payment as quickly as possible.
Fortunately, we're large enough that we're able to pay our vendors and we pay our subcontractors monthly, whether we've been paid or not.
Right.
But there are certain jobs and certain people that can't do that.
Oh, yeah.
But there are jobs that have gone on, and these jobs actually before Walt's time work down here. We were 90 to 120 days getting paid, and you billing $1 million a month. And you're out 3 months. I mean, somebody's going to the bank.
Yeah.
So, not only is the owner holding our retainage, we're having to go borrow money to pay subs and pay for materials.
Right.
And I think everybody here understands the 2.5% after 50% reduction on the retainage.
Yeah.
There is one thing two things that I want y'all to know is when we bid a job, and they all may know this, when we bid a job, we don't pay material taxes. The state law requires us to pay 3.5% tax on the contract amount. So whatever you send me a check for, we're cutting 3.5% that month to the state and sending them a check. So materials are excluded. In as far as being taxed, but we will receive a document from the state. And what's the name of that document, Jack?
MPC certificate.
Yeah, MPC certificate. We get an MPC certificate, and we have to send the government 3.5%. So in all of our bids, when someone questions the cost, we're paying 3.5%. Now in most places we pay say 10% on materials and nothing on labor. Well, that's opposite in Mississippi. Everywhere in the state of Mississippi, you will pay 3.5% of the revenue. And we've done the math, and to be honest with you, the 3.5% of the revenue is comparable to a 10% material on other jobs.
Okay.
But that's the tax that we have to pay.
Yeah.
And y'all need to know that
Yeah.
we're paying a 3.5% tax. Again, that's money that has to be put into these bids and these
Right.
front-ended things that we have to pay.
Right.
Every month that we get a check, 3.5% is going to the government.
Right. Yeah.
And there's one other thing that you may or may not know is there is an allowance through the state for a contractor to use a CD in lieu of retainage. And we do that on every job we have. The only job we have not done it for is through a FEMA related job. Any state and federal job other than FEMA, it is a state law that a contractor can use a CD in lieu of retainage. And we do that on every job that we do. And what that means is and I have this here if you'd like to. What a CD does is every month, whenever we have an estimate, we go to the bank and withdraw a CD in our name and your name, the owner's name, for the amount that the retainage would be. And that certificate is given to us and given to y'all with the interest coming to us.
Yeah.
At the end of the job, when retainage is released, y'all will sign the CD over to us. But in the meantime, you've held the CD as retainage.
Yeah, that's new to me. I hadn't
Well, it's
seen
not
that
really a
used.
new law. It was made in 2010.
But
The
you
reason
say
don't
that's
know it because it's a state law.
Right. I was about to say
Yeah.
we're not doing state projects.
But it's a state. But if it's even if it's federal money, it has to be done except for FEMA.
Yeah. Okay.
Let's see what's the issue. Accordingly, there is no discretion on the part of the contracting authority whether or not to permit substitution. And you're welcome to have this, but this is the law that we send. Certificates of deposit be issued by a commercial bank located in the state of Mississippi, provided that such certificate is negotiable or is accompanied by a power of attorney executed by the owner of the certificate in favor of the treasurer of the state of Mississippi or the treasurer of the secretary of the political subdivision involved, which would be the city or municipality.
Okay.
The reason you don't hear it is because not everyone can go get a CD for the retainer.
Yeah. Yeah.
But we do it on every job, and these gentlemen up here that knows me, they've dealt with it before and know how it works. And it isn't something we invented. So I could be.
Hey, Ricky.
Yes, sir.
It's Kevin Mullen. How are you?
I'm good, Kevin. How you been?
Good. I was just going to add that you're still probably the only contractor I've ever dealt with that's done that CD.
Well, there's not. We're fortunate that we have a checkbook that allows us to do that, and our owner, Richard Rula, has been successful because he's known how to manage his money. This became a law, then he took advantage. Why am I losing interest on my money when I can be making it? And let's go get a CD and put it in the bank. So even though it may be 0.5% right now, it's still money, it's still something coming back on your money. So it's real hard we do it on $20 million jobs. So for somebody to go take out $1 million worth of CDs is just not there. But it's available if they wanted to and if we want to. It's available.
Yeah.
Is everybody bored, or do I need to?
You mind if I take that with me and
You
make
have
copies
everything?
of
No.
it, and I can send it to all our guys with the PDH?
Anything that I brought here, you're more than welcome to take and give the guys.
Great.
And I was going to give it to it out, up front, but I didn't want them to be confused because I didn't know what order I was going to go through. And so forth.
Before you wrap up, I don't know if you're going to cover, just maybe real briefly, can you discuss the hemp hill lawsuit that went before the Mississippi Supreme Court dealing with a bid, I think, in the 10% issue? It's does that sound familiar to you?
Yeah. To be honest with you, I know what you're saying, and it'd be kind of complicated to explain to them. However, what Walt's referring to is one of the projects in Biloxi that we bid. The owner decided to award it to us instead of the other contractor who was low. And they have the right to do that, but they only have the right to do that if the contract is within 10% of the estimate. And there was some confusion on what the estimate was in Biloxi. Was it that particular job, or was it the whole pool of money that Biloxi has of their funding from FEMA on these projects?
Yeah.
And the court ended up throwing it out. But I do have an excerpt right here. This is from a state law book. Construction project negotiations authority. If the lowest and best bid is not more than 10% above the amount of funds allocated, that's where we got in trouble with the funds allocated for that particular project or for the whole scheme of work.
Right.
For a public construction or renovation project, then the agency or governing authority shall be permitted to negotiate with the lowest bidder in order to enter into a contract for an amount not to exceed the funds.
Right.
So if I'm low on something, you have the right to come to me and say, hey, you're low, but you're out of the money. Can we negotiate? Rather than going through a whole new bid process and putting people's prices out there.
I did know about that law, and we haven't used it before, but we have looked at it very thoroughly once or twice before to see if we were, close enough within that 10% of it.
There's actually a new law, that allows the owner to increase the allocated amount as long as it does not increase the ability to negotiate.
Okay.
And I haven't seen it's been put into effect yet. Do you know anything about
that?
that?
You're 100% right. We can't negotiate and increase our contract. And anything we do, we can't change unit prices, but we can change. It's more like value engineering is all it's doing. We don't need this over here. Let's cut this street out or do something like that.
Yeah. Yeah, that was another thing I've seen come up recently is that, if you've got a certain amount budgeted, but yet you've got, general funds over here that you could, move money around to rebudget for a specific project. I've heard mixed comments on whether or not that's legal or not to do that. And it sounds like this law might be addressing that.
To be more specific, and I'm going to give you rounded numbers. This particular project we're talking about was $70 million. Well, they had it estimated at 50 million or 40 million or whatever the number was. And the argument was, well, we got $150 million to do the whole thing.
Right.
But this one just got over or under the budget.
Right.
So the courts ruled that it had to be for that particular job rather than the overall funding for the entire project.
Right.
Couple of quick things that I wanted to read to y'all and that I think is more in line to what you want to hear. And I tried to work this around what y'all needed to hear from our side.
Yeah.
But this is from the state laws book, construction punch list restriction. And this is a supplement of the state law. Construction punch list restriction. The architect, engineer, or other representative designated by the agency or governing authority that is contracting for public construction or renovation may prepare and submit to the contractor only one preliminary punch list of items that do not meet the contract requirements at the time of substantial completion and one final list immediately before final completion and final payment. So we can't have a final inspection 15 times.
Right.
And somebody said, well, we're going to do this now.
Right.
Define what, you want and the contractor do it then.
Yeah.
I'm not going to read this whole paragraph, but I'm going to read 2 or 3 pages that would be important to y'all. And it's a case in point on a ruling that was with a company called Dale Construction in the United States, and it actually happened in 1964. But it's under site investigation, what y'all responsible for, what we're responsible for, and so forth. But in this particular case, the contract drawings erroneously showed the location of subsurface pipes and other items. The claims court held that the contractor was entitled to recover for the resulting damages because it neither knew or had reason to know that the plans were incorrect and thus was misled. In Barnett Briesner, the drawings showed that a drainage pipe could be installed at a certain depth and be below an existing gas line. In actuality, the gas main was squarely in the path of the drainage pipe, which was installed at the depth indicated. The contractor recovered costs for relocating the gas main. Goes back to us talking about just throwing a line on a piece of
Right.
paper. I mean, because you put it there, don't mean it can be done, and it don't mean that the contractor is liable.
Right.
There's
Yeah.
again, the responsibility of providing the information to,
Right.
to the contractor. There are 4 reasons that would cause a contractor to walk away from a job and not bid it. And y'all kind of need to know that, so you try to not let that happen. Contingent pay clause, that's a clause that provides that payment is in any way, any contingent upon circumstances other than the proper and timely performance of the contractor or the subcontractor. That there's no damage for delay claims. If any claims that provides that regardless of the cause of the delay or fault of the owner, in no event the contractor being entitled time, then you don't bid it. There's no reason to bid it. And that's what our attorneys tell us, because you can't win it in court if you put it.
Yeah.
But you're going to take away contractors that do it. No payment or compensation of any kind shall be made to the contractor for damages because of hindrance or delay from any cause in the progress of the work, whether such hindrance or delays be avoidable or unavoidable. We throw it in garbage can. We just won't bid it. Hold harmless and or waiver clauses. Bid mistakes. If a contractor makes a mistake in his bidding and it is a mathematical error, there's cause for it to be rejected, or he'd be a high bidder or whatever. Y'all make corrections.
Right.
Also, if a bidder makes a mistake and it's an unintentional bid error, that he can prove to you that, hey, here's a list of all my stuff that I had. I left this out.
Yeah.
My material got left out in my bid.
Yeah.
That is a reason to allow the contractor to be out. Or
Yeah.
to be relieved from his contract,
Right.
from the bid if he was low bidder.
Right.
One thing we see a lot of is as equal clauses.
Mm-hmm.
As equal clauses can only be identified as the key elements of function, quality, of performance. I want a blue fire hydrant instead of red. When you can't enforce that, that's not as equal.
Mm-hmm.
It's the performance of the product. Now, the pump people are the hardest people in the world to identify as equal, because I can get a submersible pump that's got 10 bells and whistles on it, and this one's got 9. Okay, well,
Yeah.
that's not as equal.
Yeah.
The color and so forth has no bearing on it.
Yeah.
As long as the function has to
Right.
be what, and we get into that a lot of times. Somebody say, well, you got a blue one, we wanted a yellow.
Yeah.
Well, we're going to paint it for you. No,
Yeah.
I didn't want that.
Yeah.
So. I talked about the golden rule. Already told you about that. These are just, I'm going to read you one more and then I'm going to let you go to lunch. There was a claim, and this is a court case, and I'll go and just read it so you'll understand it. If the ambiguity is patent and the contractor has a duty to inquire prior to contract, the failure of which will defeat the contractor's claim. If the ambiguity is latent and not discovered by the contractor prior to award, then the contractor is entitled to additional compensation if his interpretation is not accepted by the owner. As stated in Rossenman Corporation, 1968, the ambiguity in the contract documents must be patent and glaring before the contractor is required to seek clarification. In Beacon Construction of Massachusetts versus the United States, The claims court summarized the contractor's duty to seek clarification as follows. We do not mean to rule that under such contract provisions, duty to disclose discrepancy, the contractor must at his peril remove any possible ambiguity prior to bidding, which we do hold is that when he is presented with an obvious omission, inconsistency or discrepancy or significance, he must consult the government's representative if he intends to bridge the crevices in his own favor. Or that these contract provisions apply where a possible ambiguity is readily resolved by a reading of the contract. In stating of the appeal by Bromley, this is what the judge said. Contractors are businessmen, usually pressed for time and consciously seeking to underbid competitors. Consequently, they estimate only those costs which they feel the contract terms will permit the government to insist upon in the way of performance. They are not expected to ferret out hidden ambiguities or errors in the bid documents and are protected if they innocently construe it in their own favor, an ambiguity equally susceptible to other construction overlooking error. In summary, back to what we talked about, you know, the omission of things suddenly becomes a gray area and no one wins but the attorneys. And you know, whenever we don't know what you want and we thought it was something else or vice versa, then everybody's got a different opinion. When the opinions are different, nobody wins.
Yeah.
I'll wrap it up, and I appreciate the opportunity to talk to y'all. I'm glad to see some of the names.
What do you got any, I mean, we did have, a poll question during the middle of it to address your inquiry on the builder's risk. 9 out of 16 said no, they've never used it, and the other half didn't answer at all. So that was a pretty good one. What can anybody else think of a good poll question that everybody can email me and just to kind of show they participated in it? Maybe that's we just leave it at that one. How about this? Who's your favorite contractor to work with?
They don't have to answer if I don't have to answer.
But yeah, y'all just email me, tell me what you thought about the talk today, and answer either one of those poll questions, and just let me know your thoughts, and we'll send out the certificates after that. Ricky, really appreciate you taking the time to come give us a talk. Here's some little some gifts, some ASC Huggy and a gift card to show our appreciation for taking your time for it.
Well, just to let you know, in our manager's book and manual, we have.
I thought I saw a tab with ASC.
It is.
And I was curious what that was.
Well, that's what we refer to. In other words, we use that document when we're referring to claims or other things. But yeah, I did have it in here. But the whole contract is in here.
We have a copy of that Hemp Hill project manager.
You can't have this cheat sheet.
That's proprietary. It looked like it was the last one.
It is right there. So our manual includes.
Okay. Yeah.
You know, all of this and
what is,
and a lot of our documents.
CDC? Okay, yes, the general conditions.
So that's what we rely on as far as bidding to compare other things and see if what we're doing is legit or not legit.
Right.
We keep that in our handbook, and we do these handbooks. This handbook actually is provided to us by an attorney.
Yeah.
And we go through all these legal laws so that we'll know the rules and laws, just as y'all.
Right.
But I would appreciate if they would give an opinion, good or bad.
Yeah.
This is stuff we do every day, and to us, I don't say it's boring, but it's repetitive. But I do have a lot of engineer friends that call me, and you know, I hope that the information that we provide helps them in what we're doing.
Right.
And there are 3 parties to every contract. That is the engineer, the contractor, and the owner. And if those three parties are not on the same page and don't work together, nobody looks good.
Yeah.
We're never in it to try to make an engineer look bad or an owner.
Yeah.
And 99% of the time, the engineer is the same way with us. So
Right.
it's a family that you make and create once you.
I completely
accept
agree.
that contract.
I completely agree. I always try to look at all three sides of it and see, well, what is,
That's right.
I think it should be this way, but, coming from the contractor's side.
We're not
Where
always
is he
right,
seeing
and
it,
neither are the other two parties.
Right.
So there has to be enough, where people can understand that, I'm wrong in this, let's fix
Yeah.
it. And if you're always thinking you're always right, then you're gonna get into litigation.
Oh, yeah.
You're gonna bring
Oh, yeah.
problems that don't need to be there.
That's right.
And I do appreciate the, opportunity.
Yeah.
To come and talk to you.
Likewise, we thank you.
Thank
All
you.
right, everybody. Well, that wraps it up for the October meeting. We'll see you in November with Steve Sweet for the ethics talk. So y'all have a good one. Email me with any questions or comments.
Thank you.
Thank you. Thanks for.
Thank you.